Hello, and welcome back to our last section of Chapter 9 in Healthcare Law and Ethics. Again, still talking about the legal health record. This last section is going to be talking about health record disposition. So if you follow along in the book, we're at the bottom of 197. So disposition involves the removal of records from a record storage system, whether that's paper or electronic. Removal can occur for many reasons, but it's often the result of a record becoming inactive. So either the patient's not come in for so many months or years, or the patient has died, or the achievement of the maximum retention period. Disposition can include destruction or transfer to another medium or a custodian. Although healthcare organizations may not retain paper health records indefinitely for reasons such as cost and storage capabilities, organizations with EHRs may also develop disposition procedures because of the benefit of retaining older records may not outweigh their usefulness in treating the patient or fulfilling other organizational needs. So if we flip over, we get our AHIMA recommendation for determining the appropriate disposition of health records. So first of all, look at your state laws regarding retention and disposal. Second, state licensing standards. Third, CMS requirements. Fourth, federal laws governing treatment for alcohol and drug abuse. Next, guidelines issued by professional organizations. Next, the needs and wishes of patients, physicians, other providers, and public health organizations. And last, your organizational policies. All right, so let's get into the actual destruction of health records. So not every piece of information needs to be kept permanently. Destruction, which is the removal of health records from existence, should be carried out according to federal and state law and pursuant to an approved retention schedule and destruction policy. A good retention plan includes instructions and guidelines for information destruction. The plan included in an organization's policy and procedures to ensure that record destruction is part of the normal course of business and that no one particular record or group of records is singled out for destruction. Where organizations fail to apply destruction policies uniformly, or where destruction is contrary to a policy, a court may allow a jury to infer negligence. Had the record been available, it would have shown that the organization acted improperly in treating the patient. Even if they're otherwise scheduled for destruction, records involved in open investigation, audit, or litigation should not be destroyed, and we talked about this in our evidence chapter. Such destruction or spoliation of evidence would subject the organization to greater liability for failure to retain the information. Dropping down to the next paragraph, destruction policies and procedures must ensure that paper records are destroyed so that protected health information is not revealed and cannot be recreated. AHIMA recommends burning, shredding, pulping, or pulverizing. So that's how they suggest you actually destroy records. Destruction that is outsourced should be documented with a certificate of destruction once the process is complete. This certificate should include or be accompanied by a list of specific documents destroyed and a description of the manner of destruction. AHIMA recommends that organizations maintain destruction documents permanently because they may be required as evidence that records were destroyed in the regular course of business. Now, finishing up this last little section here before we get to this last slide, it talks about EHR destruction policy should include specific instructions on how information will be destroyed. Deleting information from its original location or file folder does not prevent it from being accessed from the hard drive or storage media. We had talked about some of the differences between paper and electronic information and how there was more persistence in an electronic health record because you may think you've deleted it, but it's still hanging out there in the background. It says several methods are available to permanently remove the information. Physically destroying the storage media, rendering it unusable, is the most secure means of destruction. CDs and DVDs should be destroyed by shredding or cutting, and laser discs can be destroyed by pulverizing. Overwriting of hard drives utilizing Department of Defense accepted software replaces previously stored information with a pattern of meaningless information that renders the original information unrecoverable. Hard drives may be neutralized with a magnetic field, this is called degaussing, to erase data, and magnetic tapes can be destroyed by demagnetizing. All right, so let's go to this last slide now. So, also part of disposition is transfer of health records. This includes moving a record from one medium to another or to another record custodian. Because the transfer of records from one medium to another often does not include a custodial change, fewer legal implications apply. Now, many circumstances can lead to the transfer of health records. They can pertain to smaller businesses such as physician practices, but they also occur when greater frequency, when larger healthcare organizations merge or there's an acquisition or a hospital is sold. The transfer of health record may be associated with ownership changes, and so we'll get into some of this. Now, that bottom paragraph starts talking about the HIPAA privacy rule. We're going to cover that in chapters 10 and 11. But the HIPAA privacy rule does not require the patient's authorization to carry out healthcare operations, even if it actively uses their health information that identifies them. So the transfer of records through such activities of sales and transfers are within HIPAA's definition of healthcare operations. Now, so if we have an ownership change, this is changing to a different record custodian. So this happens when a healthcare organization is sold. Now, in a physician or other provider practices where providers have shared ownership, an ownership change can also occur when one of the providers retires, they may die, or otherwise relinquishes his or her interest in a practice. In these cases, health records are considered assets and are most likely to be transferred to the successors who purchased or assume the responsibility for the organization. So if you have one physician to leave a practice, they had medical records for the patients they treated. So if you now have a new physician coming in to be a partner, those health records of that physician that retired or gave up his practice, they are an asset of that business or that clinic. And so now that's how we have an ownership change there. Now, sometimes a provider leaves a practice and goes elsewhere, but an ownership change does not occur. So when a physician goes to another practice, patients should be given the choice to move with the physician and transfer their records, or have their care and their records transferred to another provider still in that current group. So we're not talking about ownership change here. We're just talking about a provider leaving a practice and maybe going down the road. It would be like if someone at Sanders Clinic here in Tupelo, which is one of the OBGYN offices, went to OBGYN Associates. They would have the ability to take their patients with them that they had been seeing at Sanders Clinic, or that patient has the choice to stay at Sanders Clinic. So again, we're not talking about ownership changes, we're just talking about a departing provider. Now, this situation does not allow, or if the situation does not allow the patient to continue with the same physician, then the patient should be encouraged to find a new physician. Once they sign an authorization, the records should be made available to the new physician. So they will actually provide the records to their new physician if they do not choose to stay with that current practice. All right, and then the last one, when we move in information to a different custodian, is a closure of an organization. Now, many of the same circumstances that lead to a change in ownership can also cause a healthcare organization to close if a successor is not identified. Although this may occur most commonly in smaller provider practices, it can also take place in larger healthcare organizations when a hospital closes as a result of financial distress or as a part of corporate restructuring. The integrity, accessibility, and continued confidentiality of patient information following closure are extremely important. Guidance can be often obtained from the state health department or the state agency that licenses the organization that's closing. Now, and sometimes, I can use another OBGYN example, is Dr. I cannot remember what his name was, But he was an OBGYN and he had his own office. He was by himself. It was Heritage OBGYN. He closed. And so at that point in time, those records could possibly have went in storage, or they may have allowed the patients to come and get them. And sometimes you'll see notices in the newspaper or on Facebook that this clinic is closing. If you want to come pick up your records to keep, we have records from this date to this date, and they allow the patients to come and gather their information. Sometimes they will go into storage, and then you've got to figure out where they go, and so you can continue to read about that through the closure section there. Now, it talks about some AHIMA recommendations on storage options. So you can look through those, and then what happens if a storage firm is used, what provisions should be included there. And then when you drop down into that last bottom paragraph on 201, when transfer is not feasible and destruction must occur as a last resort, it has to be done appropriately. Whether the ultimate fate of health records belonging to an organization that is closing its doors is transfer or destruction, there has to be a plan to provide a patient access to his or her own information, either at the new location or prior to destruction. If a record is being transferred to a new location, only copies should be given to a patient if required record retention period has not expired. For both transfers and destruction of their health records, patients should be individually notified. If this is not possible, information about the organization's closure and the ultimate disposition of its health records should be published for distribution to the general population. Now, the bottom sentence in that last paragraph says record retention laws that govern the organization must be followed for transferred records. As with health records maintained by continuously operating organizations, appropriate record retention schedules should be followed to allow destruction to occur as legally required for health records of organizations that have closed. All right, flipping over to that last one. Now we're getting into the liability associated with loss or destruction of records. Now, healthcare organization, they're responsible for maintaining records in its custody according to applicable laws and organizational policies. When they cannot produce a health record, the risk of liability increases, particularly when it's needed for patient care or evidence in a legal action. So the healthcare organization fails to produce the health record, then the burden of proof shifts to the organization to prove that the loss wasn't intentional and there was no negligent treatment. So if you do not have a health record to back up what you did, then your liability increases exponentially. And again, it says the burden of proof shifts to you because, first of all, you got to prove that there was no spoliation. You didn't destroy the record because you're guilty of negligence, and that you weren't providing negligent treatment to your patients. Because again, that paper record or that EHR, that was your proof that you were taking care of your patient. All right, so that finishes up chapter 9 and section 9.6. So let's look at these check your understanding questions, and then we'll wrap this one up. Health record disposition includes transferring records from paper to a document management imaging system. That is true. Number 2, the most secure way to destroy electronic information is to destroy the medium that the information is stored on. That is true as well. It talked about destroying a hard drive or whatever disk it was. Number 3, when a physician closes a practice, all health records should be destroyed immediately to protect the privacy of patient information. That is false. Number 4, data in a health record should be kept permanently. That is false. One of the first sentences in one of those paragraphs said that not all data or information should be kept permanently. And number 5, when an email message is deleted, it is eliminated from an organization's electronic system. And that is false. Again, deleting something does not mean that it is gone forever. It still lives somewhere. So always remember that. All right, so that finishes up chapter 9. Like I said in the group me, I'm not going to review these sections since I did do the recorded lectures. I will post another video for a little wrap up review of sections 1 through 3 that we talked about in class. But if you have any questions, you can always email me. So again, happy reading and happy studying of Chapter 9.